Welcome to the Customary Land podcast. I'm your host, Spike Boydell. The Customary Land podcast is about all things relating to the equitable management of customary land. What is customary land? I use customary land in its broadest sense. First Nations, Indigenous and Aboriginal communities have been the stewards and guardians of customary land for millennia. In different parts of the world, customary land is called by different names. For example, native land, tribal land, nomadic land, Bedouin land, Sami land, Maori land. All of these terms represent the same intergenerational connection that's created a deep physical, spiritual and emotional identity between people and place that's been challenged and disrupted by imperialism, colonization, supplanted legal codes, development, resource exploitation, and of course climate change. First Nations, Indigenous and Aboriginal peoples are often poorly represented in dealings that impact on their customary land, and there's a significant power imbalance, meaning that the outcomes often lack equity, which results in misunderstanding and conflict. I think it's helpful perhaps to quote from the 2014 United Nations World Congress on Indigenous Peoples that defines Indigenous peoples as representing remarkable diversity, more than 5,000 distinct groups in some 90 countries. They make up more than 5% of the world's population, some 370 million people, yet they're amongst the most disadvantaged and vulnerable. Today, many Indigenous people struggle to remain on their lands and retain the right to their natural resources. Other Indigenous peoples have long since been removed from their lands, denied their languages and their traditional ways, and have consequently been left impoverished. I feel a critical aspect that's been overlooked in discussions on customary land is actually the resolution adopted by the United Nations General Assembly on the 13th of September 2007, in other words, the United Nations Declaration on the Rights of Indigenous Peoples. Now, this reaffirmed that Indigenous peoples, in the exercise of their rights, should be free from discrimination of any kind. Concerned that Indigenous peoples have suffered from historic injustices, and as a result, their colonization and dispossession of their lands, territories and resources has prevented them from exercising, in particular, their rights or right to development in accordance with their own needs and interests. The Declaration recognised the urgent need to respect and promote the inherent rights of Indigenous peoples, which derive from their political, economic and social structures, and from their cultures, spiritual traditions, histories and philosophies, especially their rights to lands, territories and resources. It also recognises the urgent need to respect and promote the rights of Indigenous peoples, affirmed in treaties, agreements and other constructive arrangements with states. It's convinced that control by Indigenous peoples over developments affecting them and their lands and territories and resources will enable them to maintain and strengthen their institutions, cultures and traditions, and to promote their development in accordance with their aspirations and needs. It also recognised that respect for Indigenous knowledge, cultures and traditional practices contributes to sustainable and equitable development and proper management of the environment, and thus the land and the resources. The Declaration also emphasises the contribution of the demilitarisation of the lands and territories of Indigenous peoples to peace, economic and social progress and development, understanding and friendly relations among nations and peoples of the world. The Declaration also recognised and reaffirmed that Indigenous individuals are entitled to live without discrimination to all human rights recognised in international law, and that Indigenous peoples possess collective rights which are indispensable for their existence, well-being, and integral development as peoples. Furthermore, it recognises that the situation of Indigenous peoples varies from region to region and from country to country, and that the significance of national and regional particularities and various historical and cultural backgrounds should be taken into consideration. Now, one thing that I haven't seen in many of the aspects that influence land for me as a property professional, such as the UN Food and Agriculture Organization's voluntary guidelines, there are 3 mentions in those voluntary guidelines to the UN Declaration. It just says, oh, you should have regard to them. It doesn't actually go into the specifics of the articles. And yet, and nor to that matter does my professional organisation or organisations in the International Federation of Surveyors, the Royal Institution of Chartered Surveyors, or the Australian Property Institute, where I am here in Australia. And the Australian Human Rights Commission has pointed out that it's really important that we should, in all dealings that impact on Indigenous people, especially when it comes to their lands, relate to the particular articles that are dealing with land issues. So what I want to do now is break down some of those articles, and I think they're going to form the basis for a number of the subsequent episodes. And I think they're things we're going to refer back to in subsequent episodes as well. Let's start with Article 8. Article 8, Section 2, says states shall provide effective mechanisms for the prevention of and redress for, item B, any action which has the aim or effect of dispossessing them of their lands, territories, or resources. So straight away, we're into a discussion about any action which has the aim or effect of dispossessing Indigenous peoples of their lands, territories, or resources. Article 10 states Indigenous peoples shall not be forcibly removed from their lands or territories. No relocation shall take place without the free, prior, informed consent of the Indigenous peoples concerned, and after agreement on just and fair compensation, and where possible with the option of return. Now, I want to stay on this point because here in Australia, where I'm based currently, the Constitution from 1901 in Section 51, subsection 31, talks about just terms compensation. And this gets really confused, and it's something we're really going to break into in subsequent episodes, in as much as what is just terms when it comes to Indigenous lands. And historically, we've seen unimproved land value. It's been said, well, this land's not improved. It's basic land. So we'll just give an unimproved land value for very sort of unfertile, sometimes, lands without having any real regard to the spiritual connection. There have been aspects, and I'm going to break into this in more detail in subsequent episodes with some of my guests, in terms of solatium and where identity construction should and can and could be valued. So we'll be expanding on that. But the other aspect was, at the end of that article, was that where possible, with the option of return. So land hasn't got to be taken forever. Land can be used, there can be partnerships, there can be leasehold arrangements for a shorter period for levels of resource exploitation in partnership with the Indigenous peoples. So there are different ways, and that needs to obviously have compensation provisions for make good at the end of any exploitation works as well, but there needs to be some quite clear opportunities, rather than just taking land from Indigenous peoples and giving them just terms compensation as at now without guaranteeing a level of intergenerational equity. We need to also look at options of return. So that impacts on all lawyers, it impacts on all valuers, it impacts on all donors, aid organisations and intergovernmental organisations who are involved in any way with customary land. So, moving on, Article 11. 1. Indigenous peoples have the right to practice and revitalise their cultural traditions and customs. This includes the rights to maintain, protect and develop the past, present and future manifestations of their cultures, such as archaeological and historical sites, artefacts, designs, ceremonies, technologies and visual and performing arts and literature. So very clearly within that we've got historical sites, archaeological locations, which means we're talking clearly here about an aspect of a land. Staying with Article 11, subsection 2 states, shall provide redress through effective mechanisms which may include restitution, developed in conjunction with Indigenous peoples, with respect to their cultural, intellectual, religious and spiritual property taken without their free, prior and informed consent, or in violation of their laws, traditions and customs. So Article 11.2 is really very important in as much as this intent that states will provide redress through effective mechanisms which can include restitution, developed in conjunction with the Indigenous peoples. So this is for property taken without their free, prior and informed consent. That would include a large part of Australia. And yes, Australia's recognised native title, but it hasn't really dealt with some of these issues at all fully. There's a lot to unpack going forward. And I think not so much as I'm going to get to in a moment, the issues surrounding the current voice in Australia for Aboriginal people, but more importantly, in terms of moving to a situation of Australia perhaps becoming a republic down the track, as opposed to the land being vested in the Crown, as it currently is in Australia. So quite a lot, as I say, to be unpacking. Article 12. Indigenous peoples have the right to manifest, practice, develop and teach their spiritual and religious traditions, customs and ceremonies, and the right to maintain, protect and have access in privacy to their religious and cultural sites. The right to use and the control of their ceremonial objects, and the right to the repatriation of their human remains. Well, this is fairly important because this gives them authority and right over spiritual sites. Secondly, states shall seek to enable the access and/or repatriation of ceremonial objects and human remains in their possession through fair, transparent and effective mechanisms developed in conjunction with Indigenous peoples concerned. Now, under Article 18, Indigenous peoples have the right to participate in decision-making in matters which would affect their rights through representatives chosen by themselves in accordance with their own procedures, as well as maintain and develop their own Indigenous decision-making institutions. Well, here we are in 2023. Australia signed up to this UN declaration on the rights of Indigenous peoples not at the time of the original declaration in 2007, but later in 2009. We're now in 2023, and we are thrashing around here in Australia with notions of giving Indigenous peoples a voice. How amazing. And yet we've already signed up to the UN Declaration as a country, which provides for all of that already. Problem is, we've got a constitution here in Australia that is somewhat archaic. It was written between 1891 and 1898, came into play on the 1st of January 1901. So it's been in place now for 122 years. It didn't really pay much regard to Indigenous people back then. That wasn't the way that Victorian constitutions were being crafted or articulated. But our governments, politicians, are harking back to say, yes, we must have a referendum on such matters to change the constitution, even though as a country we've signed the Declaration of Rights of Indigenous Peoples, and Article 18, as I say, said Indigenous peoples have the right to participate in decision-making in matters which would affect their rights through representatives chosen by themselves in accordance with their procedures, as well as to maintain and develop their own Indigenous decision-making institutions. Indeed, Article 19 goes on to say states shall consult and cooperate in good faith with the Indigenous peoples concerned through their own representative institutions in order to obtain their free, prior and informed consent before adopting and implementing legislative or administrative measures that may affect them. So we have everything in place under the UN Declaration for a voice, but we have to go back and get everybody to vote on an archaic institution because the power is held by political forces, which is very concerning. I'm going to expand on this one. There's a whole episode or more that I want to get into on issues of voice and a republic and what that all could and should perhaps mean as a point of discussion in the Indigenous context here in Australia. But moving on more broadly, because these articles aren't just reflected here in Australia, they're impacting on all those 5,000 groups in those 90 different countries around the world. So, Article 20. Indigenous peoples have the right to maintain and develop their political, economic, and social systems or institutions to be secure in the enjoyment of their own means of subsistence and development, and to engage freely in all their traditional and other economic activities. Second part, Indigenous peoples deprived of development are entitled to just and fair redress. Okay, well, there's certain amount of just and fair to be considered and redress to be considered all around the world, affecting customary land. So there's a lot for us to talk about in this podcast. Article 23. Indigenous peoples have the right to determine and develop priorities and strategies for exercising their right to development. In particular, Indigenous peoples have the right to be actively involved in developing and in determining health, housing, and other economic and social programs affecting them, and, as far as possible, to administer such programs through their own institutions. Again, the voice is provided for. Article 24. Indigenous peoples have the right to their traditional medicines and to maintain their health practices, including the conservation of their vital medicinal plants, animals, and minerals. Indigenous individuals also have the right to access, without any discrimination, to all social and health services. So there shouldn't be development that impacts on land which is used for herbal medicines and other practices without significant discussion, compensation, and redress. Article 25. Indigenous peoples have the right to maintain and strengthen their distinctive spiritual relationship with their traditionally owned or otherwise occupied and used lands, territories, waters, and coastal seas and other resources, and to uphold their responsibilities to future generations in this regard. This one's absolutely massive, as far as I'm concerned anyway, and it uses traditionally owned. It talks about ownership, which is interesting language. I'm going to break this down in the next episode as to who actually owns customary land and what that means in relationship to modern understandings. But to actually specify, Article 25, Indigenous peoples have the right to maintain and strengthen their distinctive spiritual relationship with their traditionally owned or otherwise occupied and used lands, territories, waters, and coastal areas, coastal seas, should I say, and other resources, and to uphold their responsibilities to future generations in this regard. Article 26. Indigenous peoples have the right to the lands, territories, and resources which they have traditionally owned, occupied, or otherwise used or acquired. Indigenous peoples have the right to own, use, and develop and control the lands, territories, and resources that they possess by reason of traditional ownership or other traditional occupation or use, as well as those that they have otherwise acquired. The third part states shall give legal recognition and protection to these lands, territories, and resources. Such recognition shall be conducted with due respect to the customs, traditions, and land tenure systems of the Indigenous peoples concerned. So we've got notions here of ownership and land tenure. Now, Article 27. States shall establish and implement, in conjunction with Indigenous peoples concerned, a fair, independent, impartial, open, and transparent process giving due recognition to Indigenous peoples' laws, traditions, customs, and land tenure systems, to recognise and adjudicate the rights of Indigenous peoples pertaining to their lands, territories, and resources, including those which were traditionally owned or otherwise occupied or used. Indigenous people shall have the right to participate in this process. Absolutely huge. Again, we'll expand on this notion of ownership and land tenure in the next episode. Article 28. 1. Indigenous peoples have a right to redress by means that can include restitution, or when this is not possible, just and fair and equitable compensation for the lands, territories, and resources which they've traditionally owned or otherwise occupied or used, and which have been confiscated, taken, occupied, used, or damaged without their free, prior, and informed consent. 2. Unless otherwise freely agreed upon by the peoples concerned, compensation shall take the form of lands, territories, and resources equal in quality, size, and legal status, or of monetary compensation or other appropriate redress. Whole framework for compensation for lands which have been previously taken or are taken for future activities. Article 29. 1. Indigenous peoples have the right to the conservation and protection of the environment and the productive capacity of their lands or territories and resources. States shall establish and implement assistance programs for Indigenous peoples for such conservation and protection without discrimination. 2. States shall take effective measures to ensure that no storage or disposal of hazardous materials shall take place in the lands or territories of Indigenous peoples without their free, prior and informed consent. 3. States shall also take effective measures to ensure, as needed, that programs for monitoring, maintaining and restoring the health of Indigenous peoples, as developed and implemented by the peoples affected by such materials, are duly implemented. So nuclear testing, storage of nuclear waste, etc. is been an issue, and I think it needs to really have regard to that article. Moving on. Article 30. 1. Military activities shall not take place in the lands or territories of Indigenous peoples unless justified by a relevant public interest or otherwise freely agreed with or requested by the Indigenous peoples concerned. 2. States shall undertake effective consultations with the Indigenous peoples concerned through appropriate procedures and in particular through their representative institutions prior to using their lands or territories for military activities. Obviously, here in Australia and then elsewhere in the Pacific, there's been nuclear testing. The British did it here in Australia in the 1950s and 60s. The French did it much more recently in the Pacific. So, quite a significant article. Moving on, Article 31. 1. Indigenous peoples have a right to maintain, control, protect, and develop their cultural heritage, traditional knowledge, and traditional cultural expressions, as well as the manifestations of their sciences, technologies, and cultures, including human and genetic resources, seeds, medicines, knowledge, and the properties of fauna and flora, oral traditions, literature, designs, sports, and traditional games, and visual and performing arts. They also have a right to maintain, control, protect, and develop their intellectual property over such cultural heritage, traditional knowledge, and traditional cultural expressions. 2. In conjunction with Indigenous peoples, states shall take effective measures to recognise and protect the exercise of these rights. Article 32. 1. Indigenous peoples have the right to determine and develop priorities and strategies for the development or use of their lands or territories and other resources. 2. States shall consult and cooperate in good faith with the Indigenous peoples concerned through their own representative institutions in order to obtain their free and informed consent prior to the approval of any project affecting their lands or territories and other resources, particularly in connection with development, utilisation, or exploitation of mineral, water, or other resources. And thirdly, states shall provide effective mechanisms for just and fair redress for any such activities, and appropriate measures shall be taken to mitigate adverse environmental, economic, social, cultural, and or spiritual impact. Okay, well, that's a large clause impacting on customary land. So I hope you're listening. Rio Tinto, BHP, every other mining company out there, every shareholder in a mining company, every superannuation company, organisation that has investments in mining companies, every bank that has loans to mining companies or investments associated with mining companies, and every country that's dealing with mining companies. Particularly in terms of redress and make good, this is often overlooked. And we see situations all around the world where mining has taken place or other resource exploitation has taken place, and there is no make good at the end of a process. Now, I'm going to develop in a few episodes' time a way that can be looked at as a partnership for mineral exploitation on customary land, and I'll develop that much further in that episode. But here, just a case of flagging it up to all countries which have mineral exploitation associated with customary land. Article 33. 1. Indigenous peoples have a right to determine their own identity or membership in accordance with their customs and tradition. This does not impair the right of Indigenous individuals to obtain citizenship of the states in which they live. And secondly, Indigenous peoples have the right to determine the structures and to select the membership of their institutions in accordance with their own procedures. That's all about representation. Article 34. Indigenous peoples have a right to promote, develop and maintain their institutional structures and their distinctive customs, spirituality, traditions, procedures, practices, and in cases where they exist, juridical legal systems or customs in accordance with international human rights standards. So that takes us into an enablement of legal pluralism, and particularly relevant in dealing with land. Article 36, Indigenous peoples, in particular those divided by international borders, have the right to maintain and develop contacts, relations, and cooperation, including activities for spiritual, cultural, political, economic, and social purposes with their own members as well as other peoples across borders. The second part states in consultation and cooperation with Indigenous peoples shall take effective measures to facilitate the exercise and ensure the implementation of this right. So this is particularly important to nomadic groups like the Sami in Lapland, spreading across a number of Nordic states, or the Negev Bedouin, which spreads across more than one particular area. Article 37. Indigenous peoples have a right to the recognition, observance and enforcement of treaties, agreements and other constructive arrangements concluded with states or their successors, and to have states honour and respect such treaties, agreements and other constructive arrangements. 2. Nothing in this declaration may be interpreted as diminishing or eliminating the rights of Indigenous peoples contained in treaties, agreements and other constructive arrangements. Article 38. States in consultation and cooperation with Indigenous peoples shall take the appropriate measures, including legislative measures, to achieve the ends of this declaration. Article 39. Indigenous peoples have the right to have access to financial and technical assistance from states and through international cooperation for the enjoyment of the rights contained in this declaration. I think that's really important, inasmuch as in most cases, customary peoples are not particularly well represented in law in providing for the best case when there's a compensation issue, when there's looking for redress, looking for relocation, or just for mere use of their land. In the Pacific, we've got the exemplar of what was the Native Land Trust Board in Fiji, which evolved from 1940 and has become now the iTaukei Land Trust Board, and that is held up as providing professional services and holding customary land in trust So they act on behalf of the customary landowning groups as their trust to actually undertake deals on the behalf of the customary peoples, indigenous peoples of Fiji. Now, there are problems with it, and I'm going to devote a whole episode to a discussion on what's good and perhaps what's less good about the iTaukei Land Trust Board in Fiji, but it's actually way better than having no representation. And I think the problem that they have, which I'll expand more in that episode, relates more to leasehold provisions and how the colonial laws wrote in a description of unimproved capital value, which meant there was very little compensation in most leases. It also, on lease expiry, makes it unclear or ambiguous as to who owns the improvements on the land and who owns the land, which has ended up with a level of dispossession in some ways. So it's better than what is demonstrated elsewhere in the Pacific in many ways, but not as good as it could be. So I'll come on to that one and devote a whole episode to the having representation. Article 40, Indigenous peoples have a right to access to and prompt decision through just and fair procedures for the resolution of conflicts and disputes with states or other parties, as well as to effective remedies for all infringements of their individual and collective rights. Such decisions shall give due consideration to customs, traditions, rules, and legal systems of the Indigenous peoples concerned and international human rights. So that's actually opening the door for provision of support between Indigenous peoples and the state they currently live in. So a very useful provision and would lead to recourse, one assumes, under the International Court of Human Rights. Article 41, the organs and specialised agencies of the United Nations system and other intergovernmental organisations shall contribute to the full realisation of the provisions of this declaration through the mobilisation, amongst other things, of financial cooperation and technical assistance. Ways and means of ensuring participation of Indigenous peoples on issues affecting them shall be established. So this is important in as much as it provides for support from UN level and from intergovernmental organisations to actually provide for the representation and services which may currently be provided by, in the case I previously gave for Fiji of the iTaukei Land Trust Board, a similar level of advisory provision. So I think that's sets the way for some significant guidance down the track. Article 42 of the United Nations, its bodies, including the Permanent Forum on Indigenous Issues and specialised agencies, including at the country level and states, shall promote respect for and full application of the provisions of this declaration and follow up the effectiveness of this declaration. Now, this is important. I mentioned previously the United Nations Food and Agricultural Organization's voluntary guidelines on the valuation of customary land. I think they underplayed this declaration within those voluntary guidelines, but they do make provisions, and there are free references to the voluntary guidelines. It's something that I think needs taking up with the UN FAO on those voluntary guidelines and the parties who integrated them into their understanding, which includes international valuation bodies, intergovernmental organizations like the International Federation of Surveyors, FIG, and then professional bodies as well, who may be having regard to them in compensation matters from a valuation perspective. Article 43. The rights recognised herein constitute the minimum standards for the survival, dignity and well-being of the Indigenous peoples of the world. Article 44. All the rights and freedoms recognised herein are equally guaranteed to male and female Indigenous individuals. Article 45. Nothing in this declaration may be construed as diminishing or extinguishing the rights Indigenous peoples have now or may acquire in the future. So this is getting gender equity and intergenerational equity in terms of land issues on the table. Article 46. 1. Nothing in this declaration may be interpreted as implying for any state, people, group, or person any right to engage in any activity or to perform any act contrary to the Charter of the United Nations, or construed as authorising or encouraging any action which would dismember, impair, totally or in part, the territorial integrity or political unity of sovereign and independent states. The second part of that is, in the exercise of the rights enunciated in the present declaration, the human rights and fundamental freedoms of all should be respected. The exercise of the rights set forth in this declaration shall be subject only to such limitations as are determined by law and in accordance with the international human rights obligations. Any such limitations shall be non-discriminatory and strictly necessarily solely for the purpose of securing due to recognition and respect for the rights and freedoms of others and for meeting the just and most compelling requirements of a democratic society. And the third part, the provisions set forth in this declaration should be interpreted in accordance with the principles of justice, democracy, respect for human rights, equality, non-discrimination, good governance, and good faith. So there's a huge amount to deconstruct that's going to inform and help guide us when we talk about customary land within this podcast. I think I'm going to start with what we mean by ownership and who owns customary land in the next episode. We'll touch on legal pluralism, freehold or leasehold land, land registration, and such other related issues. I've already talked about representative bodies, like taking the example of the iTaukei Land Trust Board in Fiji. And there is a whole body of discussion which I'll be bringing guests for in terms of compensation issues from specialists who are dealing in that particular field, who are trying to push the boundaries of understanding and compensation that relates to the identity component of Indigenous peoples. So going forward, what's the format of the podcast? It may well be every 2 weeks. In terms of length, I'm aiming for something between 30 and 40 minutes. I am looking to provide some opinion pieces, reflections on current issues, and also bring in a number of guests to expand the discussion. There will be a video version of the podcast, and I'll provide links in the description. Now, it's important, I think, also to provide a disclaimer. So the disclaimer is basically that the views and opinions shared in the Customary Land podcast are those of the host, me, any guests, and any others that they may cite. They do not constitute legal or financial advice and should not be construed as such by any individual, group, or organisation. Before undertaking any dealings or action relating to customary land, individuals, groups or organisations should obtain professional advice from a qualified lawyer, experienced valuer and/or certified accountant with specialist expertise in your particular country. Alternatively, you can contact Customary Land Solutions for advocacy and capacity building solutions for customary and Indigenous landowning groups and trusts on land management, leasehold, valuation and resource compensation issues. Customary Land Solutions can be contacted at contact@customarylandsolutions.com. Thanks for listening to the Customary Land podcast. I hope you found this episode interesting. If it's raised any issues for you or you'd like to get in touch, you can contact me at contact@thecustomarylandpodcast.com. In the next episode, we'll be talking about who owns customary land. Until then, stay safe, stay well, and thanks for listening.